Well, welcome everyone. We're going to just wait a couple minutes for others to join us this evening. Thank you so much for taking time out of your schedule to be here tonight. We are excited to present this webinar on the importance of estate planning. My name is Mike Kennedy. I'm the director for planned giving at the Moffitt Cancer Center Foundation. I'm excited to introduce you to my colleagues in just a moment, and I'm confident you'll find value in the information we share with you tonight. Before I introduce them, I have a couple of announcements. The first one is just a legal announcement. The information provided in this estate planning webinar is intended for educational purposes only and does not constitute legal, financial, or tax advice. Everyone's estate planning needs are unique, and it is recommended that participants consult with a qualified attorney, financial advisor, or tax professional to address their specific circumstances. Estate planning laws vary by jurisdiction and may change. Participation in this webinar does not create any professional relationship. By attending, you acknowledge and accept these terms. All right, now that we have the legal notification out of the way, I want to let you know that that after we hear from our speakers, you will have an opportunity to have your questions answered by the experts. So while we're presenting, if you think of something that you would love for them to answer, right at the bottom of your screen, you see a little Q&A box with a question mark on it. Go ahead and click on that and type in your question, and then we'll field those when we get done with the presentation a little later on. Well, let's get started. I'm pleased to introduce you to our first presenter, Erin Buss. Erin is the Executive Vice President of Development and Strategy at Southeast Trust. She is an Ocala native, has worked in the financial industry for over 20 years. Prior to serving as the Executive Vice President of Development and Strategy at Southeast Trust, she was a commercial lender for over 15 years, as well as over 3 years of experience running and growing a statewide company in the professional services industry. Her primary responsibilities at Southeast Trust are to build both client and community relationships, as well as develop and execute strategies for the expansion of the trust company. She received her Bachelor of Science in Business Management from the University of Florida, as well as her Master's in Business Administration. She graduated from Florida Bankers School and attended the Graduate School of Banking. Erin serves on the Riley Arts Center Board, Dance Alive National Ballet Board of Trustees, Blessed Trinity Catholic School Board, and volunteers at various organizations around Ocala and Marion County. Erin proudly calls Ocala home and is raising her 3 teenage boys with her husband of over 20 years. We're very excited to have Erin here. And at this time, Erin, take it away.
Wonderful. Thank you so much for this opportunity, Mike. And it's a pleasure to be with you here today. So let's start with some reflection. There are many things in life that we love or that we value. They could be our children, our pets, like what's imaged here. They could be plants or a special place that you love and you care for them. But what about when you go on vacation? If you're like me, you're going to leave some pretty specific and detailed instructions. When they eat, what they eat, where they sleep, any doctor's phone numbers if something were to happen. And you're going to ask someone that you trust to follow those instructions. Well, that's exactly what an estate plan does. It leaves detailed instructions for the things in life that you love or value, and you designate a person or a company that you would like to have follow those instructions. These documents, such as a will or a trust, lay out a plan for you and what you would like to have happen when you're not here. And the people responsible to follow the instructions in your will is your personal representative, and for your trust is your successor trustee. But we're going to get into all of that detailed information in just a minute. Go ahead and let's go to the next slide. So what is an estate plan? It's a roadmap for how you want your finances and your health care to be handled when you're not able to make those decisions. There can be many points of interest, just like little points on this map here. Think of these bubbles or points on this roadmap as possible stops on your journey, just like there's exits on a highway. Some you use and some you don't. One of those stops or exits could be a point in your estate plan, such as A spouse may not be able to make financial decisions or healthcare decisions, or a spouse passes away. One of those stops could be that you need someone to help you with your finances. Each one of these dots or locators represents potential life events. You may experience them or you may go right on past them. But no matter what, you need a roadmap that can guide you in the event that you need more directions. Your estate plan is that roadmap. It is the one that others can navigate with you to ensure that you're headed in the right direction. And by the way, it doesn't matter the size of your estate. Everybody needs a plan. Just like there are multiple types of sizes and cars and styles of cars that are on a road, they are all still driving on the same path. So everybody needs an estate plan. Let's go to the next slide. If you have not completed an estate plan, you are not alone. 67% of Americans have not completed an estate plan. I look forward to the day when this is a much smaller number because it's such an important part of your whole financial plan. Next slide, please. So, who could benefit from an estate plan? The most basic estate plan is to look at how your assets are titled and then look at who the beneficiaries are on your accounts. Look at your checking account, your savings, your IRA, your 401ks, life insurance policies, investments, and see if you have beneficiaries named. See if they're the people that you had intended. You can change them. And it's important that you look and either make sure that they're who you intended or that you even have them. Sometimes people forget to put them on. So from there, you consider if you have real estate or minor children to care for. If so, you need a little bit more complex estate plan than titles and beneficiaries. You'll need to seek the help from an estate planning attorney for your estate planning documents. And there's several ways to think about all these estate planning documents. So those of you that have minor children, a spouse who's not comfortable with financial matters, that own property in more than one state, those that want to make sure their wishes are clear and to avoid family disputes, families where privacy is a really big concern, and those who want to preserve assets and provide for loved ones in the future, you all need an estate plan. So let's look at how we can divide an estate plan into two separate categories. So let's go ahead to the next slide. So this slide represents the health-related documents within an estate plan. So listed here are some terms that you've probably seen before, but we're going to break them down just a little bit. So a healthcare surrogate, when you're alive, but not able to make healthcare decisions for yourself, this person oversees your healthcare decisions. Example, if I were in a car accident and can't answer questions about next step with my care, my healthcare surrogate can do so on my behalf. Side note here, you should always have a backup. So whoever you name as your healthcare surrogate, you have a plan A, you have a plan B, and if you're lucky enough to have a plan C, you should put one there. The next document is a living will. Some people call this a medical directive or advanced healthcare directive. You can sometimes confuse this with your last will and testament. The living will is related to your life while you are living. Your last will and testament only comes into play when you're no longer living. Your living will is a document that lets you specify your healthcare preferences in case you're not able to communicate them. It directs the providing, withholding, or withdrawal of life-prolonging procedures in the event that a person has a terminal condition, has an end-stage condition, or is in a persistent vegetative state. You guys, 2 doctors must certify that you have met one of those conditions for them to move forward with the directive. The next is HIPAA. Many of you have probably signed a HIPAA document at various doctor's offices or even at Moffitt. You can have an overall HIPAA authorization completed when you complete your estate plan. That's something that can be very helpful to you so that you have one document that people can refer to so that they can get healthcare information. So there's a difference between a healthcare surrogate and HIPAA. HIPAA is just the ability for them to get information. You could have multiple people listed. To me, I have my husband, I have my parents, I have my in-laws, I have my sister, I have my brother-in-law, because it's important for me that they know what's going on if I were in a situation that it was necessary. Some people are more private and they're not comfortable letting all those people know. But I want you to understand that you could have more than one person listed. And the last one is a do not resuscitate, a DNR. This is a document that you can get from your doctor, not an estate planning attorney. This is the medical order issued by a physician or authorized practitioner that directs healthcare providers not to administer CPR. Be very careful when requesting this and know its impact. So those are the healthcare documents that are associated with your estate plan. And oftentimes people don't realize that these are essential in creating that map. Let's look at the financial at this point. So these that are listed here are specific to your finances. The first is your power of attorney. This document is only valid when you are living. It is very powerful. The person you designate in your power of attorney to handle matters for you is called your agent or your attorney in fact. This person can act as you in all matters except vote or change your will. That means they can open a bank account, close a bank account, withdraw money, take out a loan, sell property, and the list goes on and on. They are you. So make sure that this person is trustworthy. You would need this document if you are not able to make financial decisions on your own due to incapacity or your absence. Once someone passes away, the power of attorney becomes void, useless. But the next document is what would give someone authorization to handle financial matters, and that's your last will and testament. A will is often said to be the cornerstone of any estate plan. The main purpose of a will is to distribute property to heirs after your death. If you don't have a will, disbursements will be made according to state law, which may not be what you want. You can name a legal guardian for your minor children or dependents with special needs. You will appoint someone to be in charge of following those directives. That person is called your personal representative. Most people have heard the term executor, but in Florida, we call it your personal representative. The next document is your trust. A living trust or a revocable trust is a separate legal entity that you create on your own, and it can own property or your home, investments. You can put things in your trust before you pass away. Not everyone needs a trust, but it can be used to accomplish various purposes. The person in charge of your trust is called the trustee. And while you're living, you, with a revocable trust, are typically the trustee. The next person in line to help follow those directions in that trust document is called the successor trustee. The successor trustee would start to work on your behalf if you were not able to make financial decisions due to incapacity or if you've passed away. So it's really important that both with your will and your trust, that you name someone that can follow your directions to take care of your intentions. The last thing that people should think about with an estate plan is a business succession plan. We often think about how we're going to start a business, sustain a business, grow a business. We don't think about how we will need to transition a business if the ownership changes due to the death of an owner or a primary decision maker. Business succession planning is a very important part of an estate plan and should be considered when developing your personal assets and family plan. So let's move to the next slide. A well-crafted estate plan can help bring peace of mind to you and those in your family. Working in the trust industry and serving as the personal representative and successor trustee for many people, we have seen some very well-crafted estate plans that helped continue our clients' legacy with dignity. I'm going to give you 3 quick examples. We had a gentleman who had been married for over 70 years to his high school sweetheart. She passed away in her 90s, and he did as well right after she did. We were named as personal representative. They had 3 children, 2 of which were attorneys, and 1 of which was a daughter with special needs. When Dad passed away, he knew that his 2 attorney children may not agree on everything that was put in his estate plan. So he named Southeast Trust to take charge. So we took charge as personal representative and successor trustee and were able to handle that estate so that the 3 siblings could maintain peace. And also we could take care of their special needs daughter while all of the planning was taken care of. Another example is we had a set of grandparents who wanted to see their grandchildren have success. So while they were living, the grandparents took money aside and said, we want this money to be used for their education, their first home, or a new business. So we were put in charge of holding that money and following the directives in that trust and helping see that those grandchildren were able to use it for school, a home, or for a new business. Meanwhile, the grandparents were watching and able to see how we could make sure we follow the intentions of that trust document. And lastly, we have many people who decide to leave money to charitable causes. We have one family in particular who left funds so that they could be donated to leukemia research. So we were gifted with the opportunity to reach out to organizations across the state of Florida that were doing extensive leukemia research and be able to help fund that research based off the directives in the document and gave it to charities within the state of Florida that were helping that cause. So we've been able to help many people, and it's because people took the time to have a good plan. All right, next slide. You may already have an estate plan. Thank you if you do, because you're one of the 33%, and that's an amazing goal to have checked off your list. However, do you know where it is? Some people don't know where to find it. How old is it? People should be looking at their estate plan every 2 to 3 or 3 to 5 years and review it to make sure that it is truly what you intend to have happen. Things change over time. You could have a major life event, more grandchildren, or you move to a different state. It's very important if you move that you ensure that your estate plan would abide with the new state that you are now calling home. So here's an example of how circumstances can change. 16 years ago, when I had my first children, my husband and I named my sister to be guardian, as well as the personal representative and the successor trustee. Fast forward now, and my sister, who still will be an amazing guardian, has a much larger role in her company, and she travels extensively. So for her to handle the financial matters of our home may not be the best option for her. She can handle my children, but the finances are going to be handled by someone else. So we made that change based off the change in both of our lives. So let's go to the next slide. We plan for so many things in our lives. Saving for our first car, our first house, starting a family, starting a business, saving for retirement, all the while using advisors to help us along the way. As you plan this last portion of your financial future, it is vitally important that you include your trusted advisors in this process. Seek the guidance of an estate planning attorney. Work with your accountant and your trust officer or banker. They will be able to help you and walk through the planning process and potentially help your family when it comes to ensure the documents are followed as intended. So I think this might be the best time to turn over to a trusted advisor that many have called upon for estate planning, and that would be Jon.
Thank you so much, Erin. That was a really, really great overview of what is needed to really get the process started and great examples. Really appreciate that. Next up, I would like to introduce Jon Skelton. Jon is an attorney at law and is partner of Wealth Strategies Regional Service Line leader at Shumaker. Jon focuses his practice on providing exceptional legal services to clients in the areas of general tax, corporate business, and wealth management, individuals, corporations, partnerships, limited liability companies, other business entities, and trusts and estates with interests in a broad range of industries draw on Jon's more than 10 years of experience handling corporate and business matters, including business succession planning and tax planning. He's especially skilled at finding long-term solutions designed to address the often complex individual business and family goals involved with estate planning, estate and trust administration, asset preservation, charitable giving, and planning. Furthermore, Jon represents a wide range of taxpayers in connection with audits and other controversies with federal, state, and local taxing authorities, including the IRS and Florida Department of Revenue. Jon is also a proud graduate of the University of Florida, and in his spare time, you can find Jon rooting for his Florida Gators in all kinds of weather, along with his wife and 2 daughters. He enjoys playing golf and serving on the advisory board of the First Tee at Tampa Bay, whose mission is to provide access to the game of golf to children of all ages and economic backgrounds, and use the inherent social and recreational values of the game to shape the lives of its participants. Jon, we're so happy that you're here with us today, and we look forward to what you have to present to us. Go ahead and take it away.
Thank you, Mike, and thank you, Erin, for that very good overview of just the estate planning kind of documents and process in general. So what I would like to do is kind of go a little bit more into detail on trusts, the reasons we have trusts put in place, as well as kind of some general pitfalls and concerns, things to think about when you are doing your estate planning. So why a trust? As Erin mentioned in her presentation, not everybody needs a trust, but the reason or primary reason for a trust is really for probate avoidance. I don't know how many folks have gone through the probate process, but it can be very long, very expensive. Usually when you go through it once, you don't want to go through it again. At least for most clients. It's court administered, so leaving things outside the court is generally what we try to do. A good way to do it is a trust. There are really 3 ways to avoid probate, though. Married couples, jointly titled assets. When one passes away, excuse me, everything will go to the survivor. So that avoids probate. Beneficiary designations, things like IRAs, 401ks, other types of retirement plans, so long as those are or have a beneficiary designated on it, those will also avoid probate. And then lastly, if you have assets that can't be titled jointly or don't have beneficiary designations, a trust is where you would put those in order to avoid probate. So a trust, if you put one in place, really becomes your core estate planning document. It takes the place for the most part of your will, meaning rather than your will housing where assets are going to pass, who your beneficiaries are, the trust really does that. You still have a will just in case you don't have anything that, or you didn't fund your trust. but its primary purpose is simply to pour over the assets into your trust. So with that background, why a trust? What does it help you accomplish? One of the biggest things is protecting your assets after you pass away. What does that mean? So, if you have minor kids, if you have children that have special needs or, have addictions, one of the best uh, aspects of a trust is the protection that it affords for any beneficiaries. So most trusts, every single one that I think we prepare, are what are called spendthrift trusts. So after you pass away, what that means is that a creditor of a beneficiary cannot get to those assets. So any assets that are in trust for your children or other descendants, their own creditors can't get to that. That includes, now that more than 50% of marriages end in divorce, that includes divorcing spouses. So if you have questions or want to protect assets from any kind of creditors, spouses, etc., a trust is the absolute best way to do it for your beneficiaries or for your children. One of the other big things that we run into all the time, stemming from obviously the divorce context, is blended families. You have children with one spouse, get divorced, or that spouse passes away, you get remarried, and now you've got a blended family. Your new spouse has children of their own. A lot of times clients will come in and draft what are called reciprocal documents, which are basically they have their idea, maybe we just want to leave, they agree with their new spouse, I want to leave everything equally to all children, which is absolutely fine. The problem is when one spouse passes away, and can be very unfortunate, usually there is no restriction on the other spouse to changing their estate plan. So if you leave everything to the surviving spouse in that case, they can change their own estate plan and reconfigure where you thought you wanted your asset or where you thought your assets were going to pass, to maybe reduce the amount that we're going to your children as opposed to hers or as opposed to the blended families. So we run into that very, very frequently, and it's something to definitely keep in mind. Erin touched on it, business succession planning. Our trusts are designed to be as flexible as we can possibly make them, meaning with regard to businesses, can we appoint one or more, whether it's a trust company or whether it's multiple trustees that are in the business, can operate the business for the benefit of the beneficiaries, maybe market and sell the business. So business succession planning is crafted into the document, or at least it should be. Next slide, please. So common pitfalls, and I'm going to skip right to homestead because this is a big one. I don't know what everybody knows about homestead. Florida is very protective of surviving spouses and minor children with respect to homestead property. If you have a spouse or a minor child, you are not allowed to devise your homestead to anybody other than the spouse, essentially. If you do, the device, what we call fails, and then you could be left in a situation where the spouse gets a life estate, which means he or she has the ability to live there for the rest of their life, and then the remainder goes to your children or descendants. That can lead to some very unfortunate results as well. If the spouse wants to sell the property, they need to get consent of the children or descendants who are the remainder beneficiaries, things like that. So, a lot of people I've seen attorneys who put trusts or homestead into trusts, excuse me. We generally try to avoid it simply because if the trust is not drafted correctly, you can get into that result where what you thought was going to happen isn't really going to happen. So it's something to be very, very careful with. Failure to retitle assets. As Erin mentioned, a trust is a vehicle for you to fund assets into. And when we say fund for things like real property, you would deed the real property into the trust. Bank accounts, you would retitle the bank account in the name of the trust. I can't tell you, despite our best efforts, how often clients will simply not fund assets into their trust. And by doing so, you've just completely defeated the purpose of the trust. Those assets will now go through probate, which is what we're trying to avoid. So we have a two-step process. Step A, get the trust or get the estate plan documents in place. And step B, work with clients to actually fund the appropriate assets into the trust. So you do get what you pay for, essentially. Trustees or any kind of fiduciaries who should serve as in that role. Is it the surviving spouse? Is it the children, if assuming they are over 18? Is it other family members? Is it a trust company? It all depends on what your assets are, what your goals are, how long are the assets going to stay in trust. But a lot of times we have found not enough thought has gone into who should be trustee. Again, family dynamics, litigation, this kind of ties into both divorcing spouses as well as, what your children, descendants, beneficiaries, again, who should serve as trustee. If there should be, you have 3 kids, should all of them serve as trustee? Should only one? So you got to take into account your own family dynamics in terms of what you think is the likely result. We found in a lot of cases having siblings as trustee or co-trustee of a siblings trust just doesn't work out very well, as you can imagine, especially if a sibling has the ability to restrict distribution. So things like that. We try to provide very big flexibility in our trusts for the simple reason nobody knows what's going to happen. Erin mentioned, we want 3 to 5 years or when something important happens for you guys to come back in, have a talk. Does anything need to be updated? But we try to draft our trusts in a way that have that flexibility. So if you don't come in within 3 to 5 years, something does change. There's enough wiggle room in there to meet with your goals still. And then real quick, do-it-yourself programs like LegalZoom and others, can they be used? Sure. I can tell you with 100% certainty, you're going to pay less in the vast majority of cases by going to an attorney than you are going to LegalZoom, simply because the attorney is going to have to charge you or your beneficiary's descendants a lot more money to try to fix whatever it is that happened with the drafting program. So just be careful. They can be used for sure, but you need to be very, very careful. Next slide, please. Planning for incapacity. So this one outside the scope kind of the trust, but very important to me, both from a personal perspective, having dealt with it with my wife's family, as well as with clients recently. So please, next slide. So as Erin mentioned, your 2 primary documents dealing for incapacity purposes, power of attorney and healthcare surrogate. A lot of times this is glossed over, but very, very important to consider who is going to be that agent or your surrogate under those documents. Power of attorney, for instance, and I'll say the healthcare surrogate as well. A lot of times we run into clients who maybe their spouse has passed away, they don't have children, or their children are out of state. So they can certainly be appointed as power of attorney or healthcare surrogate, but there are certain limitations to being out of state, for instance. If something needs to happen healthcare wise, or you have an elderly client or who falls or needs medical attention, being out of state presents some logistical concerns. And I'll give you kind of an example in a minute of something that we're going through or have gone through recently that kind of really drives home that point when we're talking about incapacity planning. But why the power of attorney? Why the healthcare surrogate? The real reason for that is to avoid the need for a guardianship. Simply, just like probate, guardianship is court administered, very expensive, very cumbersome. We generally want to avoid it to the extent we can. Easiest way to do it is with the power of attorney and the healthcare surrogate. So when I say gaps in good planning, so we've had a recent situation where elderly client recently had her spouse pass away, named her nephew as both the power of attorney and healthcare surrogate. And this is more where the rubber meets the road in terms of incapacity. You have a situation where your agent or your surrogate can act for you, but your decisions or the client's decisions trump any decision your agent or surrogate make on your behalf unless you're incapacitated. So you can get into a situation where it's borderline. You need help. The agent or the surrogate is there trying to help you, but at the end of the day, if a physician or medical professional or a court has not determined you to be incapacitated and you're not incapacitated, you have the power to make decisions for yourself. So even if your agent or your surrogate are acting what I would think of in your best interest, it's your decision. If you don't want to seek medical help or don't want to go to a nursing home, you can make that decision. You can decide to live at home until you've been determined to be incapacitated. So it can lead to some very, very unfortunate results. Obviously, in our situation, the agent and the surrogate ended up resigning simply because the client wouldn't listen to them, wanted to do her own thing, which is her prerogative for sure. But things like that's what I'm talking about in gaps in good planning. There are situations that you just simply can't plan effectively for, unfortunately, in some cases. So next slide, please. I am just going to touch on this briefly because I don't know how many people have taxable estates versus non-taxable estates. And I promise this is going to be my only political comment. You see here on this chart for 2024 and 2025, we have very large exemptions. 2026, those exemptions are scheduled right now to be cut in half. So if you have, in these cases, $27 million, $28 million, and you don't use your applicable estate tax exemption, which I'll explain here in a second, then you would effectively lose it in 2026 once it gets cut in half. So to take a step back, your estate tax exemption is essentially the amount of money you can give away both during life and at death without paying any estate taxes at all. So when we have our sunset at the end of 2025, or at least what it's scheduled to sunset, again, if you didn't use your exemption, you would lose it. So that's, let's take an individual. You just lost $7 million of exemption at a 40% tax rate. That is $2.8 million, if my math is right, in additional tax that you now owe because you didn't use your exemption when you had it. Now, back to my political take. Now that the Republicans have won both obviously the presidency as well as the Senate and the House was just confirmed, in all likelihood, these exemptions are going to be extended. Nobody knows for sure, but this is less of an issue now than it was when everybody thought there was going to be a split in the House or a split in the Senate, and or the Democrats winning or retaining the presidency. So less issue now than there was, but I just wanted to highlight that. Next slide, please. And we just touched on the election and congressional dynamics. I'm not going to go into great detail regarding the exemptions and what our planning are, but just know there are various techniques in addition to the basic estate planning documents. We have a kind of two-prong approach there. Put our basic documents in place, which Erin has already gone through and we've been talking about, and then do your more complex estate planning, which includes irrevocable trusts, getting valuation discounts for transferring businesses, et cetera. So there are much more advanced techniques which are outside the scope. I just wanted to make sure that we at least got those down. And then next slide. Finally, charitable planning. There's no right way or wrong way, I think, to do your charitable planning if you're so inclined. Obviously, during your lifetime, you can give away whatever you want to charity, get an income tax deduction for it, make a gift directly to Moffitt or to another charitable foundation, or for me, the First Tee. That's the charity that I like to um, help. You can do that during lifetime. There are, what I wanted to touch base here real quickly, retirement accounts. You can gift out of retirement accounts if you have required minimum distributions. You can take up to $100,000 and give it to a charity out of your retirement account each year, and it's not treated as a distribution out to you, so you don't owe taxes on that distribution. So that's a good way if you are charitably inclined and do have an IRA or 401k or other retirement account to give to charities. At death, in the terms of your trust or your will, you can certainly leave a lasting legacy to a charity as well as your beneficiaries. Foundations, donor advised funds for those who are extremely charitably inclined. You can have a donor advised fund set up at various institutions, and that kind of pools families' charitable giving and helps kind of guide the process for younger generations. So just wanted to at least throw out there the different options you have for charitable planning, both during lifetime and at death. And I believe I am going to stop there.
Jon, thank you so much for going a little deeper on those different instruments. Very, very thorough. We're very appreciative of your time and for going through all that. We do have some questions coming in. Just a reminder, if you do have questions, feel free to just go down to that Q&A box at the bottom of your screen, and we'll get to those in just a minute. I did want to just tell you a little bit about the Moffitt Foundation. I have the privilege of being on a great team here at the Moffitt Foundation. The foundation is here to really raise money to help with research, help with patient care, and it does that through a variety of different ways. The team that I'm on is the Plan Giving team, and we help our donors who will leave Moffitt in their estate plans, similar to what Jon had mentioned. The Moffitt Legacy Society honors individuals who have included a gift for Moffitt Cancer Center in their will or trust, or by beneficiary designation of an IRA, a life insurance policy, or other instrument. The Legacy Society is made up of members like you who are either a patient, a family member, a friend, or even an employee at Moffitt who really cares about the job that Moffitt is doing, have left Moffitt in their estate plans. Give you a couple brief examples. An example, we recently had a grateful patient who just went through his treatment. He was so pleased with the care that he received that he and his wife just informed us that they were going to leave 80% of their estate to Moffitt through their trusts and their IRA. Had another example of a volunteer who included Moffitt as a $10,000 beneficiary of their IRA. So it could be a percentage, it could be a specific amount. It doesn't matter the amount. Every amount counts and goes to become a member of the Legacy Society. You have many ways to contribute. Most importantly, you become part of Moffitt's long-term mission to contribute to the prevention and cure of cancer through groundbreaking research, education, and patient care that continues to save and change lives. We just ask that as you complete your estate plan and your financial planning, we ask that you consider to making a gift to Moffitt or to your favorite charity as part of your legacy. And both Jon and Erin, myself, and our team here can also help with that. I think we now have time to switch over to the Q&A section of our webinar. We have our panelists. I'm going to go ahead and just field these, Erin and Jon, and we're going to start. We have a couple questions around who should be my personal representative and successor? Would you advise that the designee for the will or trust is someone with whom you have a personal relationship? I know you touched a little bit on that, but Erin, would you touch a little bit more on that if you just who to select or how to select a good personal representative or successor trustee?
Absolutely. So in the state of Florida, your personal representative must be a Florida resident. If you have a Florida-based document, which if you're a Florida resident, you should have a document that is a legal document in the state of Florida, and the execution of those documents is different in each state. So Jon could probably talk through those details, or your estate planning attorney could, but your personal representative either has to be a blood relative or a Florida resident. So if you decided and you wanted your personal representative to be your brother and they live in Michigan, that's okay. If you wanted the personal representative to be your neighbor who is a Florida resident, that would work as well. But going to your question in regards to, is it good to have a person do it rather than a company, or can you kind of avoid maybe some emotion through that? And that's where a trust company could come in. And so that's why many people will choose a company such as Southeast Trust to be able to help and serve as the personal representative. In regards to the successor trustee position, that can be anybody that you believe that could make sure that your intentions are followed as you have them written in your document. But the role of a trustee can be very diverse, including making sure the assets are invested appropriately, communicating with those advisors that we spoke about earlier, and ensuring that the long-term goals of your estate are taken care of if that is part of your estate plan and the distribution of the property. So to summarize, you can choose almost anybody, but you want to make sure they have the capacity to make sure that your intentions are followed. So a trust company such as Southeast Trust could serve as your personal representative or as your successor trustee. But then as a personal representative, if you wanted to name an individual, it has to be a blood relative or a Florida resident. Jon, do you have more to add?
Not too much, but I'll weigh in on. I saw one of the questions referenced, maybe an attorney serving as a fiduciary, a personal representative, or trustee. I can tell you, we do run across that from time to time. It Us personally at Shumaker, we do not serve as personal representative or trustee. I think there's a pretty big likelihood of potential conflicts of interest that are just kind of inherent in doing so, but some attorneys certainly do it. We don't. And then the last thing I'll just add in, when you're talking about who should be that trustee, and Erin can give you this as well. When you're naming a trust company, or when it's somebody, part of the question was if it's somebody you have a relationship with. I think whenever you name a corporate trustee or a trust company, you want to have a relationship with the people that you're naming. So when you name them in your document, what we'll do a lot of times is make the introductions. You want to know who it is, have comfort that they both know you personally, know your family, get to know you, and are going to do the job that you want them to do.
Great. Thank you so much. One of the questions that came up is regarding Florida documents versus another state. What if an estate planning document from another state, or if they have one, what if I have estate planning documents from Florida, but plan to move to another state? I'm going to add on to that. What if I own property in Tennessee or another state, and I also own property here in Florida? Jon, you want to field that?
Sure. I'll do it in both ways, both in and out. So if we have obviously clients coming into Florida with documents from other states, the good news for those individuals is that Florida recognizes valid documents that were executed in other states. So if you come into Florida with a will that was in New York, that's going to be recognized here in Florida. It is a very, very good idea, and I would recommend it to everybody to go to a Florida attorney immediately when you move into Florida, if that's what you're doing. Simply to make sure, just a quick example, we have a self-proving affidavit in our wills, which essentially kind of validates the will. So when you go to probate it, you don't need to get witness testimony or affidavits if you have a self-proving affidavit that's attached to your will. A lot of states don't have that. So when you execute your will in that other state, it doesn't have that. So you pass away in Florida, now you're left, or your beneficiaries are left with trying to track down who those witnesses were in another state, which can be near impossible if the documents were executed 20 years ago. So that's just a small example. So very, very important, I think, to at least have somebody document or look at it and make sure it complies with Florida law and meets with our requirements to ease doing anything. Same thing if you're going out of Florida. Some states, I can't name them off the top of my head, but I think some states have restrictions on out-of-state documents that they'll recognize or how valid they will be. So absolutely, if you're moving out of state, same thing applies. I think you should go to a estate planning attorney in that state that you're moving to, have them review the documents and advise. Real quick, Mike, you asked about the real estate. If you own real property in another state, so you're here in Florida, this is where you reside, this is where you pass away, you own property in another state, you're going to have to do what's called an ancillary administration in that other state to deal with that property. So that means you have not only a Florida probate that gets opened, you have an out-of-state probate that gets opened. So you'll have to deal with that. A way you can avoid that is by putting that property into, an LLC or funding it into your trust. So when you have out-of-state property, you certainly want to be proactive and plan for it.
Thank you. Another question. The term pour over will has been mentioned. Can you explain what a pour over will is, Erin?
Sure. And Jon mentioned this in his presentation as well. So if you have a pour over will, that means that you have set up a trust. And so the intention of that will is to be a catch-all for anything that you did not retitle into your trust. So it would be almost like it'll catch anything that you didn't put already in the trust, and it will then pour over into the trust. So it's just a way to ensure that your intentions, if you forgot an IRA, if you forgot a checking account, if you forgot something, you have designated in your will that you want everything to go into your trust and then to follow the directives that are in your trust. So everything pours over. So almost like a pitcher. It's going to pour over into your trust if it's not titled into your trust.
So they don't have to be registered in the name of the trust. They can just go pour over, like you mentioned. That's great.
It does make things a little more difficult. So
That's right.
it's better if you have things, if you have a trust, please title those assets in a trust. And then the pour over part is just meant to be for items that you may have forgotten.
Another question, is there a way to guard against a surviving spouse changing the estate plan in a blended family scenario? Jon?
Absolutely. So rather than leaving assets directly or outright to the surviving spouse, you leave it in a trust for their benefit and or the benefit of the family. So they can, and we didn't talk about it, but trusts are literally can be structured however you want. I say the world is your oyster to clients who come in. So whatever those terms are that you want, the trust can likely be structured. So, you leave it in trust for the benefit of the surviving spouse. They could be a trustee. They could be a co-trustee with other family members if you really want to make sure it's protected. You put restrictions on the distributions that they can make to themselves. And by that, I mean, they would be restricted to, if they're serving as trustee, they would be able to make distributions to themselves generally for what we call our ascertainable standards, which are health, education, maintenance, and support. Health and education, everybody knows what those are generally. Maintenance and support are a bit more fluid, but basically your normal standard of living is what those are primarily designed to kind of capture. And then you'd have the surviving spouse or a co-trustee could potentially make distributions in excess of those, but you would generally restrict the surviving spouse from making any purpose distributions to them. But
Right.
a trust is the way you would do that. Leave it to them in trust.
And Erin, are trusts filed at the courthouse, or how do you make it a legal document?
So it is not filed at the courthouse. A will is. And one of the benefits of a trust is that it's private. A will, and if you have to go through probate because you haven't done estate planning, that's a very public experience where things are you do go to the courthouse, you have to file the will no matter what. You have to do that if you have one. But it's a more public event where your assets could be exposed and people could kind of find out more about your family and your finances. If you have a trust, it's a private document. And it becomes legal because you have it appropriately executed and written by an estate attorney. So they're able to make sure that it is done appropriately. And then you have someone that you name that can handle the distribution of property and handle those assets as your successor trustee. So it's not filed at the courthouse.
Thank you. And one last question. What is the minimum amount to become a member of the Moffitt Legacy Society? I will field that one. Any amount, any gift to Moffitt is appreciated. We just ask that you just put in writing with a simple letter of intent that we can send to you what your intentions are. And we would love to have you as part of the Legacy Society to be able to steward you and thank you during your lifetime for including Moffitt as part of your plans. Well, that's going to do it. I just want to thank everyone for being here tonight. I want to give a special thanks to our presenters, Erin and Jon. Thank you so much for giving of your time and your expertise. Really do appreciate it. I do want to let everybody know that the three of us are here to help you with your planning. If you have questions, we're going to follow up this presentation with our contact information. So you'll have that available, and we'll make sure that we'll get the answers to any questions that you might have. But as you plan for your family, as you plan for your future, as you plan for the charities that mean the most to you, just know that we're here to help you. And again, thank you so much for being here tonight. Good night, everyone.